First, in number 70, 18, Roe against Wade.
Since the first abortion thousands of years ago, abortion has been a popular form of birth control, and as a result of this has been much debated. The ancient civilizations of Greece, Rome, and Egypt, as well as all ancient societies where the father had absolute control of the family, used abortion as a legal form of birth control. Abortion carried over to America, where there were many laws put in place to prohibit or limit the use of abortion and contraceptives. In 1873, the Comstock Act, an obscenity law, prohibited all contraceptives. At this time, the law regarding abortion was that a woman could only receive an abortion if her life was in danger. However, this law was expanded to include protecting a pregnant woman's life if the baby is deformed, or if the woman became pregnant due to rape as a reason to get a legal abortion. There were also many court cases prior to the Roe v. Wade case that contributed to the final verdict. These cases involved problems like fetal disease, contraceptive practices, and the right to perform abortions. In 1963, a woman named Sherry Finkbein tried to get a legal abortion when she learned her baby could potentially have a fetal disease due to a drug she was taking. She was denied this abortion in the United States and was forced to fly to Sweden in order to obtain an abortion. In the mid-1960s, there was another major court case that shaped the abortion and contraceptives debate. The 1965 case of Griswold v. Connecticut was a key predecessor to the Roe case because the Supreme Court gave married couples the right to use contraceptives based off of their right to privacy regarding their own health. This decision was revised further in the 1973 case of Untied v. Bard. The Supreme Court ruled that unmarried people had the same access to contraceptives as married couples. Some conservative states, such as Texas, made abortion illegal when the mother's life was not in danger. This was later the main focus of the Roe v. Wade case. In the 19th and 20th centuries, there have been millions of illegal abortions performed throughout the United States. In just the year 1936, it was reported that there were over 500,000 illegal abortions performed. The average amount of children a woman had in the 1800s decreased substantially by the 1900s. The average woman in the 1900s had about 3.5 children, while in the 1800s a woman had on average 7 children. After examining the census of 1880, Dr. P.S. Haskell reported that there were 1 abortion for every 6 live births. According to the Michigan report in 1881, more than 100,000 abortions were performed, and more than 6,000 people died immediately from the effects of receiving an abortion. Abortion became one of the first things a doctor could specialize in within the American medical practice. Every year as of 1966 in America, there are between 200,000 and over 1 million illegal abortions on mostly married women, despite the many laws against it. It was estimated that abortion rates rose from about 1 in every 30 live births from 1800 to 1830 to close to 1 in every 5 live births in 1850 to 1869.
The reported early abortions, of which the greater number of course escape registry, bear the ratio to the living births of 1 to 4.04 in New York, while elsewhere in the world there are only 1 in 78.5.
Dr. Alicia Harris in 1860. The change of abortion law in the United States all started with a 1972 class action case filed by Norma McCorvey under the alias of Jane Roe. McCorvey was born in Louisiana in 1947 as Norman Nelson, but was raised in Texas, a notoriously conservative state. McCorvey was abused as a child by her uncle as well as by a nun, and at the age of 16 she married Woody McCorvey, who abused her as well. Eventually she moved back to her parents' house in Dallas. In 1969, McCorvey unintentionally got pregnant, but knowing she would be unable to care for the baby, she said that she was raped in order to obtain an abortion. However, because of a lack of evidence, this plan did not work, and it was admitted 15 years later that the entire story was fabricated. She later was referred to 2 lawyers, Linda Coffey and Sarah Weddington, in order to file an individual case to get an abortion in Texas. However, this case took 3 years to reach the Supreme Court, and by this time was considered a class action case, meaning that the verdict the Supreme Court came upon applied for all women seeking an abortion, not just McCorvey. By this time, McCorvey's child had already been born and subsequently put up for adoption, but the class action case filed by McCorvey forever changed the United States abortion debate. The Roe case opened along with the Doe case in the Supreme Court on December 13, 1971. From the beginning of the case, it was clear that the final verdict would hinge on how the court interpreted the right to privacy mentioned in both the 9th and 14th Amendments of the United States Constitution. Because these amendments were not specifically written regarding abortions, the amendment is left up for debate and interpretation, as well as how the court defined the word person in relation to a fetus. In the Constitution, the aforementioned right to privacy mentioned in the 9th and 14th Amendments allowed a person to privately make decisions regarding their personal welfare. This left the final major question. Is a fetus a person, and does it have the same rights as a person? By January 22, 1973, the Supreme Court made the decision that the right to abortion is based off of a doctor-patient relationship, which is protected by the right to privacy, as well as that a fetus is not considered a person. These two decisions made abortion a matter of personal choice and therefore completely legal in the first 3 months of a pregnancy. This decision was based off of a proposal made by Justice Harry Blackmun, which states,
"Right of privacy, whether it be found in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or, as the District Court determined, in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy."
The verdict of the Roe case preceded the next decision around the Doe v. Bolton the same day. In this case, the abortion law of the state of Georgia was called into question. Here, Justice Potter Stewart determined,
"The 9th Amendment obviously does not create federally enforceable rights."
This effectively made abortion a legalized right in America and forever changed the abortion debate. A failure of legalizing abortion was that some women used abortion as a form of birth control after they got pregnant. Abortion was a backup plan rather than planning ahead to prevent a pregnancy. The Roe v. Wade and Doe v. Bolton cases successfully gave a woman the right to have their pregnancies aborted at their own discretion. This was a monumental step in the women's rights movement because it gave the mother the full right to choose whether or not to go through with her pregnancy, as well as eliminating illegal and therefore unsafe abortions. While everyone may not agree with abortion, what is indisputable is that the verdict of the Roe v. Wade and Doe v. Bolton cases forever increased the safety of abortions by legalizing and thus making it a controlled practice. This belief that in personal health, legalized government controls, procedure, and law are best still comes up to this day in the war on drugs.
Good evening. In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government. Thus, the anti-abortion laws of 46 states were rendered unconstitutional.
On the legal side of things, these cases successfully created an interpretation of the right to privacy. Because the United States justice system works mainly off of interpretation of the Constitution and off its precedent, meaning the past cases hold a lot of weight, the decision made here around the 9th and 14th Amendments may be the most important aspect in future legal decisions. What the Roe and Doe cases failed to do was put an end to the debate surrounding abortion. In fact, consequently, from the Roe and Doe cases came two vastly different beliefs regarding abortion: pro-choice supporters and pro-life supporters. These two cases helped to ignite the motivation behind both of these groups and made the debate stronger than ever. Pro-choice supporters believe that women have the final say on whether or not to keep their baby due to the aforementioned right to privacy mentioned in the 9th and 14th Amendments of the Constitution. This means that they fully support the decisions by the Supreme Court in both the Roe v. Wade and Doe v. Bolton cases. The major support of the pro-choice comes from the Democratic Party. The Democratic platform, which states the political beliefs for the party, states that 84% of its members support pro-choice abortion, while the rest of the members have no opinion. The pro-life group believes that the Roe and Doe cases were mistakes and should be reversed. This side has a great deal of support. Many pro-life activists believe that a fetus has the right to live, which is a main argument against abortion. The point of existence as to when a fetus becomes a person is frequently argued between the pro-life and pro-choice groups. Two prominent groups that are publicly pro-life are the Republican Party and the Catholic Church. The Catholic Church has been against Roe from the beginning, saying that any member having an abortion would be excommunicated. Similarly, 84% of Republicans on the national platform are pro-life, while the other 16% say they have no opinion on the issue. As of today, 34.7% of the population are in favor of protecting the right to abortion, while 49.6% favor the restriction of abortion, while this leaves 15.7% of the population undecided about abortion. Based on these numbers, it is clear that the majority would prefer overturning Roe v. Wade. Having said this, even if the majority of the population disagreed with Roe, this does not mean it should be reversed. Remember, the job of the Supreme Court is not to reflect the thoughts of the majority, but rather to make new policies based off their interpretation of the Constitution and the precedent of the past decisions. The justice system works in part because they build off of past decisions. A reversal of an almost 40-year-old decision of this magnitude would cause too much instability within the U.S. justice system, causing a ripple effect forcing many other decisions to be revisited. The legalization of abortion was only viewed as a success to some because the pro-life group did not support legalizing abortion. They fought to reverse this law by saying killing a fetus was unconstitutional and wrong. The Roe v. Wade and Doe v. Bolton court cases determined this not to be true, a win for those who are pro-choice. However, the verdicts of these two cases did nothing to end the debate. While it drastically changed things legally, it only continued the debate over legalization of abortion, a debate that has gone on for hundreds or even thousands of years and is still seen every day in religious, political, and ethical circles.